Today, I am deeply, deeply honored to have a special guest with us here in the Terracotta Room, Florida Supreme Court Justice John Couriel. Do you ever come across cases where you think, oh, these guys across the street should have changed that law?
Yeah, I think that's a common experience for judges.
You're listening to A Deeper Dive with Dara, a podcast by the News Service of Florida.
Hello and welcome to A Deeper Dive with me, Dara Cam. I know I say it all the time, and every guest is special to me and to all of you deeper divas, but I am really beyond thrilled today to have in the Terracotta Room with me live and in person, Florida Supreme Court Justice John Couriel. Yes, it is true. Right here, live in person, Justice John Couriel. Welcome to the Terracotta Room and welcome to A Deeper Dive.
Thank you very much for having me. I'm afraid you may be overselling me a little bit, Dara. It's very nice to be here.
No, Justice Couriel is a very smart and funny person, and I know this because I have watched him and listened to him, and I think you're all really going to enjoy this episode. I want to just start out a little bit about some of your history.
Sure.
Your parents emigrated from Cuba in the 1960s.
Yes.
And your father was a Pedro Pan. I don't know if that's the
Is a Pedro Pan.
That's right. He's a Pedro Pan, and I actually watched your investiture ceremony yesterday, so I learned all kinds of little snippets about you. I won't mention the posse of nerds. Ooh, I just
there
did.
You go.
Okay.
Yeah.
But how did your parents' experience influence you as a child and as an adult now?
Well, I often tell people that my parents are the most grateful humans I know, and I think that influenced me. I think it can't help but influence you as a child if your parents model gratitude. And in my father's case, he's very grateful to the United States and for the United States. He's a very grateful American. I always tell people he's the most grateful American I know. My mother, too, is someone who made the most of every opportunity she had professionally, rose and sort of surmounted to many challenges. And she, too, has a spirit of gratitude, not a spirit of grievance about anything. And so I grew up feeling very lucky. And that became part of the way I look at the world, look at government.
In many ways, you're sort of the epitome of the American dream. You and your family.
That's very kind of you to say.
You went to Harvard. You got a law degree from Harvard. You're a Florida Supreme Court Justice appointed in your 40s, young man. You could serve 30 years on the court if you wanted.
That's funny. It's now true of a majority of the court.
Yeah.
It's a young court now.
It is.
And I think that is to our benefit as a state. But, to the point about the American dream, I often tell people that Miami is the most American city I know.
He's from the 305, y'all. I forgot to mention that. Right.
And the American dream is like not a dream in Miami. Everybody around you is an entrepreneur, has a hustle, is making the most of his or her time and opportunity. And that was the environment in which I grew up. It was a spirit of, gosh, it's great that we're here. Let's make something of it. And that's just part of, I think, it says less about me and more about the place, more about our country and our community.
I want to go back to some of the things that I learned about you, remembered about you, relearned when I listened to your investiture ceremony. That's hot tea.
I'm good. Okay. But I like that you're concerned about my well-being.
I am concerned about it.
It's very good. This is the kind you like, right?
This is my kind. It's lemon zinger.
It's very good.
Okay, good. So I was listening to some of your friends describe you as an old man inside a child's body.
I feel like I've finally caught up with myself, and it's great. I'm 45, and I think I was 45 when I was like 12. So a lot of my friends remember me as sort of a 45-year-old in a 12-year-old's body. I finally feel normal. It's great.
How was that? Why was that? Were you just like a very serious child?
Yeah.
Were you thinking of, what it was going to be like to be a Supreme Court justice someday?
No. I think, one thing I often tell my law clerks is that, as a young person, as a young lawyer in particular, you derive a lot of your happiness and meaning in life from where you think you're going, not where you are. And as we all get older, I think we learn, that it matters to derive happiness from where you actually are. And this job in particular is great because it is a final destination.
Sure.
And so I feel very fortunate that at a relatively early moment in my life, circumstances sort of encourage or force you to derive meaning and happiness from where you are and to stop thinking about where one might be going.
Living in the present, living in the
making
now.
a difference, making an impact.
Now.
And to return to the theme of gratitude, and being grateful for the fact that I have the capacity to do this job for as long as I get to do it, and to wake up and attack it every morning. So I feel very grateful for that.
I think I feel the same way in a much different way, but I feel every day, and I've been doing my job for a lot longer than you've been doing your job, but I still, after decades of doing this job, I wake up almost every day excited about doing my job and grateful that I'm looking forward to some new
It's
challenge.
an important job. Look, when we were, I don't want to cut ahead of you here, but when we were at the Reporters Workshop, which Paul Fleming tells me our court has been doing for 30 years, that's where you and I met and talked about my coming here. And what I said I at the time was how I enjoy being a consumer of long-form audio journalism like this, because I think it allows people who have an interest in something to go deep and to really come away with a better understanding of a subject in a way that is not the predominant mode of media inquiry these days. I love the fact that podcasts are a new pillar in media because it allows people who have a genuine interest in something to really learn. And so I was very excited to do this, and I understand why you would be excited to do this. This is so much more interesting than doing quick hits, right?
Yeah.
You get to really shed light on issues that matter and to really spend time with them, and I think that's a good job.
I think I want to brag, though, because you did say that you are a fan of the Deeper Dive podcast.
It's a really good podcast, yeah.
So should I just do like, yay me?
Yeah, yay you. Yay you. It's a great podcast. I enjoy it.
Oh, wait, hang on.
Very good. That's not bad.
Yes, we are very honored that you listen and that you're here with us. And I think it's very important for people to be able to get context, especially nowadays when we're so, in our corners and we select the kind of news that we allow ourselves to consume and process. And it's oftentimes very lopsided, and I feel like that's really kind of a dangerous.
Like everything else, I think there are features and there are glitches to it. I think it is in part feature that people get, more information that they choose, but there are glitches when it comes to living in a pluralistic society that come with that. I myself, as just a consumer of news, I try the best I can, and I like the news. I don't pretend to not like the news. In fact, it's one of the tougher parts of the job is understanding and remaining clear upon your constitutional role. I frequently tell people that, if you find a court's decisions unpalatable, if you don't like a court's decisions, that hardly speaks to the court's legitimacy, because for structural reasons we know that at least somebody leaves court unhappy every single day, right?
Sure.
So the legitimacy of the system cannot depend on whether or not you agree with the court. What it depends on is whether the court remains in the constitutional lane that it's been given. And as a consumer of news, you have to remove your judicial hat, put on your news consumer or your voter hat, and we all do it. And then when you take on this constitutional responsibility, you stay in your constitutional lane. So I kind of feed myself by listening to the news, given that I can't, write it or make it anymore.
Right.
But I do like listening to a variety of viewpoints.
I do love when, listeners will hear me say this all the time, it might sound familiar to you, when my guests get to the questions before I do, because you're kind of feeding into what I was going to ask you about the way that the court works.
Yes.
And the perception that there is a perception out there among some people that courts, justices, judges will vote a certain way, will rule a certain way, depending on who appointed them. So I want you to tell us why that's not true.
I am so glad you asked. So you may believe that power is just power, right? And there's a, very well-developed school of political theory, in fact, several of them, that would tell you there's really no such thing as the legislative power, the executive power, the judicial power. There's just power. Trouble is, that's not our system. You may believe that all you like, but our founders used the definite article the in describing the judicial power, the executive power, the legislative power, and they did that on purpose. They understood that those powers were different from each other, and they circumscribed them in our foundational documents. And this is, I'm speaking about the federal Constitution. We can speak more precisely about the Florida Constitution. It's a little different. But those powers were different and distinct from each other. And the ultimate ability to say what the law ought to be is a power that our framers found too significant to leave in the hands of judges. That power belongs to the listeners of the show as exercised through their elected representatives, the political branches, the executive and the legislative. So that's the power to say what the law ought to be. Judges don't have that power. I don't have the power to say what the law ought to be. It is our job to say what the law is. And that's not just a semantical difference. The difference is cases that come to us generally require us to exercise the judicial power. Well, what does that mean? It means largely we're dealing with facts as framed by a conflict between two parties or a limited universe of parties, generally retrospective in nature. It's about something that happened. Generally, there are times when it's about something that might happen. And our ruling speaks to the case before us. Of course, it speaks to other similar cases by way of the way the common law works. When we resolve a case, it sets down a rule about how the exact same case might be handled. That's very, very different, though, from the work that happens across the street and the work that happens in the governor's mansion, where as the elected representatives of the listeners of this program, those folks get to say what the law ought to be, and if you disagree with them, you throw them out of office. So when people look to the courts to tell them what the law ought to be, we have a functional problem, because that's not what our system is. Our system is predicated on the political branches doing that work. I fear that often in the reporting, and it's actually part of the reason I wanted to sit down with you, is this doesn't get relayed. People wind up reading news stories about a court like they would read a news story about the legislature or the executive. And that's just a failure of our civic educational program, I think, because it's not the way you're supposed to analyze the work of a court. The work of a court is analyzed on the basis of the individual cases it's resolving at that time and what that resolution of the case says to society, to future litigants. Not that we are trying to figure out what would be best, not that we are flying on the basis of our gut. Now, there are people with a different judicial philosophy than mine. There are people who think that it is the role of a judge to do substantial justice or promote equity or be progressive or promote whatever virtue you think is right. I, as a failed politician...
we'll get to that in a moment.
I understand I don't have that power. I knocked on a lot of doors. I tried to get elected, and the people said, no, thank you. And I'm very grateful they did. But I understand the consequence of that. The consequence of that is I'm not a policymaker. In deciding cases, I don't sit there and think about what ought to happen, what is right for, John in this setting to rule. I do the best I can to figure out what the law is. And when I say that, I mean what the legislature has said and what the common law is. And those are two different, we can talk about those differences, so what statutory interpretation is versus what the common law is. But in both of those spheres of decision, what I'm trying to do is I'm trying to figure out where the ball actually lies and to say so clearly in a way that people will get it.
Don't go anywhere. We'll be right back with Florida Supreme Court Justice John Couriel.
Here at Deeper Dive, we want to hear from you, the listeners. We invite you to send your questions, comments, and feedback to our mailbag. You can reach us at deeperdive@cityandstatefl.com. That's deeperdive@cityandstatefl.com. Get your 2 cents in by sending us an email.
Welcome back to A Deeper Dive with Dara. Well, I hear what you're saying, and I'm not going to try to debate you because you were on the Harvard debate team. And
I was a high school debater.
Okay, well, you debated at Christopher Columbus,
That's right.
I believe.
That's
and
right.
so you were an award-winning debater, and you went to Harvard Law School.
I
So
did
I'm
do
sure
that.
there was a bit of debate that went on in those
It's how I met my wife. We debated against each other.
That's right.
Yeah.
That's right. But I just want to push back a little bit because when you say, we're going to, it's the rule of law and the court, when the court overturns, let's take Dobbs, for example.
Yes.
This was the rule of law for 50 years, that a woman had a right to an abortion.
Well, where did it come from? The rule overturned in Dobbs was another judicial decision, right?
Right.
It wasn't laid down by the legislature. It wasn't laid down
It was
by
an
executive.
interpretation of what the right to privacy meant.
Mm-hmm.
So I don't want to get too much into
No. See, this is, whenever I sit down with reporters or community groups, I always tell them the same thing. You're not limited in what you can ask me. You can ask me anything you like. I'm the one who's limited.
I don't want to talk specifically about the abortion issue. I want to talk about precedent and the courts, your court, and not just the U.S. Supreme Court, has now shown not only, a willingness to depart from precedent, and not just gazillion-year-old precedent. I'm thinking of more recent cases. And so how do the voters wrap their minds around, okay, this is not a politically motivated court or rule or ruling. This is their interpretation of what the law says when it seems to depart so strongly from what we have known to be law and case law for so many years.
Right. So I think the straight answer to your question is by judging the reasoning of what a court has said. A case decided in 1973 and, decided on the merits presented to that court in 1973 must ultimately sort of stand for what it stood for at that time. And the question is the logic still good? Is the reasoning still good in 2023? I think when I work with precedent, you want to show deference to the work of a prior court, and you want to make sure that people have settled expectations about the rule of law, while also being critical about the reasoning behind those settled expectations, and to be able to say when something is clearly erroneous, when something is fundamentally wrong, that even if we've been doing it for a long time, we don't need to abide by it. Plessy versus Ferguson was the law of this country for a long time. And Plessy was wrong on the day it was decided. And it disrupted a lot of people's expectations when Brown versus Board of Education rejects the rule of Plessy.
He's talking about
segregation.
Right.
and all of the arguments for precedent, when taken to their extreme, would have been reasons for keeping Plessy. And yet the Supreme Court rejects it. Rejects it because it is finally willing to admit that the reasoning of Plessy was wrong. And I think that's a helpful lens for looking at the work a court does. If you find the court's reasoning arbitrary, if you find the court's reasoning flawed or light, that's a good reason for criticizing a court. Simply adhering to precedent because it's been settled for a long time does nothing to tell us whether the precedent was one worth sticking to.
There's something in law, and I had it in front of me, and now I can't find it because I'm too giddy. So, but it's something that's called evolving standards
Of decency?
Is it?
That's an Eighth Amendment, like cruel or unusual punishment concept.
But so it's only for that I come across that a lot in my death penalty coverage.
That's something you'll talk about that you'll hear lots of people talk about in the death penalty context.
Right. So then we don't consider that in other areas.
It's not that we don't consider it.
Standards of like evolving standards. I guess this is my question.
I get to talk about originalism now.
That's
this is great.
That's exactly what I wanted to talk. Yeah, that's where I was taking you, because things are different now than they were in the 1700s.
Yeah.
So tell us why originalism is so important to justices like you.
Right. It's very easy to talk about originalism and to project it back into the 18th century when what you're trying to do is weaken the claim that originalism makes.
Yikes.
So let's not go so far back.
Okay.
The legislature passes a law today, passes a law last session. The deal is what binds us. Not the intention of any legislator, not the intentions of the legislators writ large. The words on the paper are the deal in a democratic society. We're not governed by the intentions of the people we elect. We're not governed by their secret wants and desires. We are governed by the bargain they strike, signed by the executive. That's what the law is. That premise, as true of the legislation that was passed last session, is also true of something passed 50 years ago or 100 years ago. Nothing evolved to change that deal that we just get to sort of tape over what the legislature did. The legislature, acting in its constitutional lane, gets to amend the deal, right? If you don't agree with something that is the law, you have a way to change it in a democracy. Elect people who agree with you and change the deal. The fundamental premise of originalism is that we respect the deal that was struck. We don't try to amend the deal outside of the democratic process. An originalist is someone who cares a great deal about democracy and won't allow the authoritarianism of the enlightened or the ennobled to say what the evolved standard of decency or the evolved idea should be that we sort of read into the clear words that a legislature has passed and that an executive has signed. This is not a revolutionary thought. This is, this goes back, I would say centuries in American jurisprudence, and it is frequently caricatured as, a project to be socially retrograde when all its premise is that words have meaning and effect, and that the meaning and effect we give to words is the meaning and effect that an ordinary speaker and user of the English language would have given to them at the time the words became the deal.
And technology, the development of technology, the changes in society, changes in how we communicate, all of that, you have to interpret how those changes, how to apply what those words meant at the time?
No, they don't change the deal. These changes in our society can be made to change the deal across the street from us. Like if you think the words on paper as, enacted 50 years ago no longer ought to be the deal, change them. Get somebody elected and change them.
Do you ever come across cases where you think, these guys across the street should have changed that law?
Yeah, I think that's a common experience for judges, but it's not. In fact, we often say in our opinions, without talking about any of them individually, we'll often say this is a matter appropriate for legislative consideration.
As a matter of fact, I was just reading, I had this little game that I do where, and I just started it, where I don't look at the author if it's not a per curiam opinion. And I was just reading an opinion, and I got to about page 5, and I said, aha, this is Justice Couriel.
And it sounded like me.
And it was you. It was you. And
what did I say this time, Dara?
Do you want to know which case it was?
Sure.
It was the Marcy's Law case.
Oh, yes. Yeah.
And in that, the reason that it made me think, I'm shaking my finger at the justice. Jeez,
you're allowed to.
The reason that it made me think of you is because you did say in there, the legislature can change this, but right now this is what it says.
I want to be very clear. That's not an abdication of a hard subject. When we do that, it's not because something is too hard. It's because, to go back to what I was saying earlier, the people, this is a little different in the state system, and I'll come to how it's different in a minute, but the people didn't elect me to solve that problem. The people didn't elect any of us to solve that problem. The footnote is that in Florida, as in many states, we have merit retention, which means there is a check on the governor's authority to just appoint whoever he likes on the court. And I think one way to think about merit retention is that it substitutes structurally for Senate confirmation in the federal system. I don't know which one is better, to be honest with you. I think, the federal system has pronounced problems in the confirmation process.
Yes.
Having been through the retention process now once, I think it's fine. I think it does give the people a check to say, look, if someone is really not staying in their constitutional lane, out. But what it isn't is a mandate to be representative. People always say, oh, do you feel like it's important, that you're representing this or that on the court? I don't represent anyone. It's not my job to represent anybody. I'm not a representative. I was put where I was not in a representative capacity, but in a capacity to do a job. And that job is to say what the law is.
I didn't feel like, and forgive me if it came across as I was saying, but I didn't feel in that opinion at all as if you were, abdicating at all. I felt like you were saying, well, you did say, this is what the words say. Go back to your originalist approach. You said, these are what the words say. It doesn't apply, not only does it not apply to police, it also doesn't apply to anyone. It doesn't create an exemption for the name of any victim. Only information that can identify where they can be located. So I thought, and then you said, and much more eloquently than this, but hey, legislature, have at it if you want to. But it was not at all any way of saying of sidestepping.
No, I didn't mean to respond that way. I'm just and without speaking.
No, but I think that's an important point to make, that it's not that you're not doing. You're not motivated by saying, oh, we can't.
That's right. Without speaking to any individual case, I will tell you that, that is a frequent, that's part of what we do in making a decision. The first question any court has in deciding a case is jurisdiction. Every court must decide first whether it has jurisdiction to do something. And that's a fancy lawyer word for whether or not this is within our power. And when struggling with that, as we always do, the first question is this the kind of problem that people hired us to solve? That's another sort of more workmanlike way of describing what jurisdiction is. And oftentimes when you're discussing your jurisdiction, you realize that something is more of a legislative issue, and you say so when that is the case. It's now it may not be jurisdictional. It may be that a question is within our jurisdiction, but as a matter of prudence, we want the political branches to be involved. But again, that's just part of the judicial project, is are we the right people to be answering this question?
I wanted to talk about, you mentioned merit retention. Mm-hmm. The Florida justices face a mandatory retirement age at age 75.
Yes. Unlike
the U.S. Supreme Court, where they are appointed to life terms.
Yes.
Life term sounds a little, maybe not pejorative. So which do you think is better? Are you allowed to have an opinion or express an opinion
I don't know.
on that?
I think it's great that I will have an opportunity to seek parole when I'm 75. I look forward, I hope I'm blessed with that long on this earth and on this court, and if I am, I think it would be great at that age to look for another challenge. But do
you envision yourself staying on the court?
I do.
Really?
I do. I mean, unless the people have other ideas.
Because you could make piles of money doing something else. As the governor said at your investiture, that you gave up a paycheck or a big paycheck to take the job because you were in private practice at is it called a white stocking?
They say white shoe.
White shoe. I always call it a white stocking. I don't know why.
No, I loved every second of my time at Davis Polk and at Couriel and Kim. I have lots of great teachers, and I learned a lot, mostly from adversaries and clients, and also partners and folks for whom I worked. And so those chapters in my life as a sort of a young lawyer in private practice, and then as a partner at a firm, mm-hmm. Those are good chapters. But I don't want another one of those chapters. At least, 45-year-old version of me is pretty sure that he's not interested in any of that.
That's really breaking news here. We just broke some news here.
Congratulations, people of Florida. You're stuck with this guy for the next 30 years. Yeah, breaking news.
A Deeper Dive with Dara is hosted by Dara Cam, produced by Ryan Daly, and music for the podcast was recorded by Periodic Labs, LLC, and performed by Ryan Daly and Danny Reyes.